Grant Robertson.
Mr. Chair, for the call. That's terrific. I also want to talk about Section 26, or Clause 26 rather, within Part 1, which relates to the new provisions on disclosure of information, in this case to the Australian Taxation Office. And by way of background, Mr. Chair, what's happening here is effectively that New Zealand has a new arrangement for the exchange of information regarding student loans, which was signed between the Commissioners of Inland Revenue of Australia and New Zealand in March 2015. And this sits alongside a range of provisions in New Zealand law to exchange information with other taxation jurisdictions. For instance, double taxation agreements, which we have with Australia and with around, I think, 40 other countries, and also what are called, as this is, a taxation information exchange agreement, which we currently hold with 11 countries, Mr. Chair, not 12 countries. Malta is not on the list of countries with which we have a tax information exchange agreement, despite what the Prime Minister told the House last week when he stood up and said that we did have a taxation information exchange agreement with Malta. We don't. He hasn't come to the House and
student loans here.
Well, point of order, Mr. Chair.
Point of order, Grant Robertson.
Mr. Chair, we are indeed, and what we're specifically talking about, if I refer to the commentary on the bill provided to us by the Minister, is an arrangement for the exchange of information. They all have capital letters on them, those words, and I'm currently working through the arrangements for information exchange that are in law.
Yeah, taking the member's point of order, we're talking about, and I refer specifically to the clause that he's talking about, which is data disclosure of information with Australian Taxation Office. And if he wants to make some side reference, then he's done that, and he should move on.
Thank you, Mr. Chair. So, as I was saying, this clause is governed by, as it says in new 209A1, the purpose of this section is to facilitate the exchange of information between the IRD and the Australian Taxation Office. And, Mr. Chair, what I was pointing out was that we have a double taxation agreement with Australia. This is an additional agreement, a taxation information exchange agreement, just making the point that we don't have one of those with Malta, and waiting for the Prime Minister to correct that. Mr. Chair, the reason that we have this clause in here is to enable a much clearer line of communication between our Inland Revenue Department and the Australian Taxation Office. And there are certain details that are now required to be able to be exchanged. Those details in 209A3 include the borrower's name or any other name by which a borrower is known, a borrower's date of birth, a borrower's tax file number, a borrower's last known address and contact details, and any other information that the Commissioner considers relevant for the purposes referred to at the start of the section. That's quite a comprehensive set of details about student loan borrowers. And indeed, and in fact, I really, the first one's well worth a little going into a little further. A borrower's name or any other name by which a borrower is known. That is actually a comprehensive way of identifying who a student loan borrower is. If we compare that to other disclosure arrangements that Inland Revenue has, and I'll put this question to the Minister, in fact, as to whether he would like to compare that and see whether he thinks there's fairness here for student loan borrowers versus, for instance, those who run a foreign trust in New Zealand, who actually can get away without even saying what the name of the trust is. If you don't know what the name of the trust is, you don't even have to put it in the form. No, you've just got to describe it. You don't actually have to put the name in it. So, you know, a question for the Minister as to whether he thinks it's fair that student loan borrowers have this obligation, but those people who want to avoid paying their tax elsewhere in the world don't even have to put the name of their trust down, Mr. Chair. And we can say the same thing here about the extent of these disclosure arrangements, because there isn't any doubt in this. There's no might if. Information has to be collected and available and shared. And it is that sharing that is the essence of this clause, Mr. Chair. It's not just about making sure that a student loan borrower keeps that information. Because if we were comparing this to other disclosure arrangements in tax law, the person who is the settler of a trust, a foreign trust in New Zealand, just has to keep the information. They don't have to share it with anybody. They don't actually have to make it available. They just have to keep it. And I wonder if the Minister would like to tell us if that's fair. If student loan borrowers, who I think everyone in this House acknowledges should meet their repayment obligations, that's an important part of having taken out a loan. But why is those sorts of obligations not on other types of people who interact within the Revenue Department, Mr Chair? And I'd like to hear the Minister justify some of those concerns, Mr Chair.
David Bennett.
Thank you, Mr Chair.